We might start with Cliff. I think you guys are fine with Cliff.
GAO.
Oh, the GAO ones?
Do you want to check?
Yeah. So we can start with that one, and then we can get to the ones you may not. I think we can do that. We might start with. Committee will come to order without objection. The chair is authorized to declare a recess at any time pursuant to Committee Rule 2 and House Rule 11, Clause 2. The chair may postpone further proceedings today on the question of approving any measure or matter adopting an amendment for which a recorded vote is ordered. Now recognize the gentleman from Oregon to lead us in the Pledge of Allegiance.
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank the gentleman. Pursuant to notice, we call up 1398 to Protect America. Excuse me. I want to call up. I want to call up Mr. Banks's bill.
296, the blue one.
8296 is got it. Pursuant to notice, I call up H.R. 8296, the GAO Database Modernization Act, for purposes of markup, and move that the committee report in favor to the House. The clerk will report the bill.
H.R. 8296 to amend Chapter 8 of Title 5, United States
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Oregon, Mr. Benz, for an opening statement.
Thank you, Mr. Chair. 8296, the GAO Database Modernization Act of 2024 is an overdue piece of legislation that will add clarity to the database of federal regulations. This bill will help Congress and the American people identify regulations that have been repealed or amended. Under the Congressional Review Act, administrative agencies are required to notify Congress and the Government Accountability Office, known as the GAO, when the agency enacts a new rule. GAO is an independent, nonpartisan agency that works for the Congress. Its purpose is to help the government save money and work more efficiently. The CRA process allows Congress to review and, if necessary, bring a resolution to reject the new rule within a certain time frame. The notification process also allows the GAO to maintain a publicly available database on all federal rules. This publicly available database allows the American people to access information about rules and regulations that govern their lives. Under current law, however, agencies are not required to specifically notify Congress or the GAO if an existing rule is amended or revoked. As a result, regulations appear on the GAO database without any indication that the rule is no longer in effect or has been amended. This bill seeks to fix this problem going forward. The GAO Database Modernization Act would require that when an administrative agency submits a rule under the CRA's requirements, it must also send a brief report notifying the GAO if any existing rules are revoked or amended and a description of those changes. This bill would allow the GAO to clarify on its database changes to regulations. The number of final rules published each year is generally in the range of 3,000 to 4,500, and there is currently no required method of tracking when new rules change prior rules. The GAO wants this information so it can provide the American people with clarity regarding existing regulations. This common sense, narrowly tailored bipartisan proposal will ensure that the American people have access to complete and correct information about the rules that govern their lives. I recommend my colleagues support this proposal, and I yield back.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, the GAO Database Modernization Act would amend the Congressional Review Act to require federal agencies to report to the Government Accountability Office, or GAO, certain information about agency rules that are made ineffective due to an agency action or other reason. The Congressional Review Act, or CRA, requires an agency to submit a report to both houses of Congress and to GAO whenever it promulgates a rule. This reporting requirement enables Congress to be kept regularly informed of rulemaking activity by all administrative agencies. GAO has created a publicly accessible database tracking all rules submitted by the agencies. However, agencies do not currently report updates, suspensions, or alterations of rules to GAO unless any modifications are part of a newly promulgated regulation. In order to increase transparency, this legislation amends the CRA to require agencies to submit a report to GAO on rules that are revoked, suspended, amended, or otherwise made ineffective. While I do not oppose this legislation since it has very little effect, I do want to note that I have concerns with the underlying Congressional Review Act, and I hope that we will have an opportunity to examine whether the law is operating as intended. The CRA, which provides a fast-track process whereby Congress can overturn an agency regulation, has become a favorite tool of the Republican majority to undermine life-saving regulations that protect public health and safety. Regulations take significant time, resources, public input, and expertise to craft. But the CRA allows narrow partisan majorities in Congress to do away with them without any of the deliberative process that went into making them. And because the CRA also prohibits an agency from issuing another rule in, quote, in substantially the same form, close quote, without congressional authorization, it allows Congress to tie an agency's hands well into the future. I will support this legislation as a modest improvement to oversight and transparency, but I hope that this is just the beginning of a larger conversation about the CRA and its impact on the regulatory process. Thank you, and I yield back.
Without objection, gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Oregon for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 8.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair recognizes the gentleman from Oregon to explain the amendment.
Mr. Chairman, this amendment strikes the year from the title of the bill. It's not intended, this amendment, in any way to alter the substance or important purpose of the bill. I urge support for my amendment, and I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Arizona is recognized.
Thank you, Mr. Chairman. I'm wondering if the gentleman from Oregon might be able to answer my question, and that's simply this. Will the rule that is modified or revoked or suspended, et cetera, will it still be seen by the public with just the notation in the public database? Or is there going to be an effort to actually remove that revoked or suspended rule from the CR, or excuse me, the Federal Register?
You're yielding to me.
Yes, sir, I yield to you.
Well, thank you for the question. I would just refer you to the language on the face of the bill, which reads, the federal agency shall submit to the Comptroller General's office a report containing the title of the rule, the Federal Register citation for the rule, if any, the date on which the rule was submitted, and a description of the provision of the rule that is being revoked, suspended, replaced, amended, or otherwise made ineffective. So if the agency is going to submit that to the Comptroller General, then it's going to be up to the Comptroller General to appropriately reflect that change. That's all I know.
Okay. I support the legislation. I just, at some point, if you're revoking the rule, I would hope that we delete it from the congressional record at some point. Thank you. I yield back.
Gentleman yields back. Who seeks recognition? Question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up 1398 to protect America's innovation and economic security from CCP Act for purpose of markup and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 1398.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Texas, Mr. Gooden, for an opening statement.
Thank you, Mr. Chairman. H.R. 1398, the Protect America's Innovation and Economic Security from the CCP Act, focuses our attention on countering the single greatest threat to the American people and our future, the Chinese Communist Party. I want to share a quote with you that may sound familiar. There is no country, none, that presents a broader, more comprehensive threat to our ideas, innovation, and our economic security than the Chinese Communist Party. And in many ways, it represents, I think, the defining threat of our era. This is not just some ordinary statement, but the testimony before this committee of FBI Director Christopher Wray, Director Wray and the rest of the intelligence community have been echoing these concerns since the turn of the decade, labeling China as the defining threat of our generation. These warnings aren't without merit. In the past 3 years, there have been a significant number of CCP-backed espionage cases perpetrated against the U.S. and U.S. companies. The sectors most frequently targeted by these espionage activities are our intellectual property and academic institutions, which are the bedrock of American innovation. Trade theft alone costs our economy over half $1 trillion annually, and the CCP is responsible for most of that. And while the intelligence community has been sounding the alarm on China's persistent infiltration of our society, economy, and infrastructure for years, little has been done to address the problem. On the contrary, we've taken a step back, and without justifiable reason, we've shuttered programs that prioritize these concerns at a multi-agency level. In its place, we have an unofficial shadow policy to counter the CCP, one that lacks a concrete approach and even worse, lacks accountability. And aside from lacking a proper approach, very little progress has been made under the new policy. No longer having a prioritized focus on the CCP's espionage activities and rolling back dedicated programs to counter these threats only emboldens the CCP. Such a casual, nonchalant approach to arguably the greatest threat of our lifetime is no laughing matter. Now, one of the reasons for the Biden rollback of the Trump policy or the program was the worry for racial consequences. And so we are not naming it what it was named. And I think one of perhaps the worst affected from this rollback are those of Chinese ethnicity, because Chinese American citizens and the people of Chinese origin in the United States are identified and disproportionately targeted by the CCP to carry out their schemes. The CCP is also known to target, harass, and trap people, especially those of Chinese ethnicity, who don't play along or are perceived as dissenters, the bar for which is extremely low. And allowing these activities to continue without an appropriate initiative to counter them puts our people, especially Chinese Americans, who are our people, at the greatest risk of being exposed to the CCP's cruel tactics. The CCP initiative under this bill will make the DOJ effectively and actively counter espionage activities in areas most notoriously targeted by the CCP with a comprehensive and well-rounded approach. It sets a clear goal of countering CCP espionage in areas critical to American innovation and national security. To meet these goals, it creates a framework inclusive of interagency cooperation between the DOJ and the FBI for a multifaceted approach. In addition to interagency cooperation, there are reporting mechanisms that keep Congress involved and updated about the DOJ's progress, which ensures appropriate accountability and oversight of agencies under this program. The strong, dedicated, and accountable approach under the program will also discourage and deter new attempts to infiltrate our country. And I urge my colleagues to vote in favor of safeguarding our country, our people, and our future against the greatest threat of our lifetimes and support H.R. 1398. I reserve and yield the balance of my time.
Gentleman yields back. The chair now recognizes the ranking member for a statement.
Thank you, Mr. Chairman. Mr. Chairman, in 2018, the Trump Justice Department launched what it called the China Initiative. While it was ostensibly designed to counter efforts by the Chinese government to steal American intellectual property, the program ultimately had few successes. For nearly 4 years, the National Security Division brought a series of unsupportable cases against Chinese academics at the height of their careers. The government was forced to drop many of these prosecutions. Others failed in court. Even more were overturned on appeal. The China Initiative was born out of the understanding that a strategic priority of the United States is countering national security threats from China. Had the DOJ gone in a different direction from this starting point, we might be here lauding the successes of the, quote, Defend U.S. Trade Secrets program, close quote. Instead, the Trump DOJ invested significant resources into targeting individuals of Chinese descent working in the United States, diverting crucial funding and personnel that could have been used to combat economic espionage and trade secret theft across the board. But the China Initiative did not just waste valuable resources. Rather than keeping Americans safe, the China Initiative divided workplaces, ruined careers, and contributed to anti-Asian hate. If you were a person of Chinese descent working in American higher education, you were a suspect. Rather than keeping America safe, the China Initiative divided workplaces, ruined careers, and contributed to anti-Asian hate at the height of the pandemic when tensions were already high. Many of my colleagues who served in this committee during the pandemic remember the vitriol, the careless word choice, and the characterization of otherness directed at Asian Americans during that time. Programs like the China Initiative with its explicit targeting of Chinese citizens working in the United States only served to amplify these tensions. For many of us, the clear drawbacks and minimal successes of the program were obvious in real time, and I am proud to say that I opposed the China Initiative throughout its short existence. And I was glad to see the program ended in early 2022 by the Biden administration. Unfortunately, this legislation, which would establish a, quote, CCP initiative, unquote, at the National Security Division, would simply reestablish the China Initiative by another name. My colleagues across the aisle have repeatedly suggested that without the China Initiative, we as a country are not being tough on China. What the majority fails or refuses to realize is that programs like these are wholly ineffective at protecting our intellectual property. In fact, they do the opposite. During its 4-year tenure, the China Initiative stifled innovation by discouraging foreign talent from moving to American companies and prevented Chinese researchers from accepting positions at our institutions of higher learning. We cannot quantify those missed opportunities. There is no way to know what inventions never came to be, but we can realize when we made a mistake and move on. This bill would prevent us from doing so. I appreciate that my colleagues have been circumspect when talking about the national security threat posed by China. But it is imperative that we differentiate the many people who live and work in the United States from the threat posed by the government of China, not just in our words, but in our actions. It is also concerning that this bill would reestablish a pillar of a program that was repeatedly used to target Chinese professors working at American research institutions. Countries around the world send their best and brightest to the United States for education and to perform valuable research in our academic institutions. But instead of welcoming their contributions to our economy and to our society, programs like the China Initiative encourage them to take their training and their talents elsewhere. In a September 2022 report by the Asian American Scholars Forum, researchers found that between December 2021 and March 2022, 42% of the over 1,300 faculty members surveyed nationwide reported being fearful of conducting research in the U.S. A further 61% felt pressure to leave the U.S., and 45% intended to avoid federal grant applications. It is foolhardy to punish China by harming American innovation, but by discouraging researchers from working here, that is exactly what we did. The IP subcommittee has conducted several bipartisan hearings on the threat posed by the Chinese government's theft of trade secrets. Democrats and Republicans agree that there is a real significant threat to our national security. But this committee has more important things to do than revisit failed Trump-era programs. If anything, we should expend our oversight resources ensuring that the DOJ is not simply following the practices of the China Initiative in all but name today. This legislation would take us in the opposite direction. I oppose the bill. I encourage my colleagues to do the same, and I yield back the balance of my time.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from Texas for the purpose of offering an amendment in the nature of a substitute.
Mr. Jordan, have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute to
Without
HR.
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair recognizes the gentleman from Texas to explain the amendment.
Thank you, Mr. Chairman. What we're doing in this amendment is consolidating objectives and goals in Part A and C of Section 2. We're also substituting the steering committee with a consultation and reporting requirement, and we're removing discretionary authority in prosecuting under the CCP initiative due to concerns regarding the constitutionality of removing the DOJ's discretionary authority. And so instead, we've added a reporting requirement that requires the Attorney General to submit an annual report to House and Senate committees on Homeland and Judiciary. Yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I move to strike the last word. We've seen this movie before, and it did not end well. On the IP subcommittee, on which I am ranking member, we have discussed real concerns about economic espionage by the People's Republic of China. But while I have legitimate concerns about actions by the government of China, setting up a CCP initiative, as it's called, within the Department of Justice does nothing to counter those threats. Instead, it would encourage racial profiling, destroy the lives of academics, and create a chilling effect on the United States' attractiveness to international scientists and to people who want to study U.S.-China relations. Department of Justice had a China initiative from 2018 to 2022 with the stated goal of cracking down on Chinese economic espionage and theft of trade secrets. That China initiative failed to achieve any productive outcomes related to economic espionage. While it failed to achieve its stated goal, the China initiative caused significant real-world harm. Many academics faced long-term personal and professional damage, and a fear of association with the China initiative created a chilling effect on researchers of Chinese descent. Chinese American scientists reported that fear of added scrutiny and discrimination kept them from pursuing cutting-edge research and made them avoid federal grant applications. These were Americans who just happened to have Chinese ancestry, yet they felt unsafe and targeted in their own country because of the China initiative. That's terrible, and it was not just Chinese scientists. A 2021 survey of thousands of physicists found that 43% of early career researchers believed the United States to be unwelcoming for international students and scholars. And there was a chill as well on research in fields seeking to study U.S.-China relations. Wisely, the Department of Justice canceled this program in 2022 because it was a failure then, and it would be a failure now. So let's leave it in the past where it belongs, and with that, I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Maryland.
Thank you, Mr. Chairman. I had some concerns just from reading it. I'd ask the author of the amendment about this. In Section 2A, this appears to be identifying the targets of who this entity would investigate. And it speaks about intellectual property, academic institutions, and subparagraph 2, and then researchers in labs, universities, and defense industrial base. Is it the gentleman's goal that private high-tech companies would be protected by this language or not?
In my view, there's not any specific exclusion for any private company or public company. So if you read differently than that, I'd be happy to work on it. But I'll let you finish.
Well, no, I'm not disagreeing with the gentleman, but to the extent it becomes, the statutory interpretation becomes, well, if Congress had meant that to be included, they would have included it. I would urge the gentleman to consider that. Let me be up front. I'm going to oppose the bill, but these are things if it's going to pass.
This is a new revelation for me to hear you say that.
I would ask the gentleman to consider these issues. And then the second big one that I would raise, on page 2, under 6, prioritize and identifying and prosecuting those engaged in trade secret theft, hacking, economic espionage, which I would presume references private high-tech companies that we were discussing before, but doesn't specifically. But also move into page 3, under requirement, the bill, and I take it the gentleman's goal is to make sure that this entity doesn't do any work or become involved with any other programs or initiatives at the Department of Justice. But given the use of the word prosecuting on the previous page, I'm assuming the goal is not to exclude potential criminal prosecution. But the way this is written, I don't know that the national security wing of the Department of Justice, just typically they might say, for example, want to bring on one of the U.S. attorneys or combine a national security prosecutor with one that actually does the trial work and taking it to court for a criminal prosecution. As I read this language, that might be precluded, actually. And, you know, it might go beyond that as well, because it looks like they're under C2 on page 3, all resources shall not be combined to support any other Department of Justice program, including other programs and initiatives dedicated to countering nation-state threats. So I picked the criminal piece because I think that one's fairly dramatic. If we identify one of these cases and we actually have a potential to prosecute someone for, you know, criminally for stealing trade secrets, I would hope we wouldn't have a statutory barrier to facilitating that. And there may be other variations of that too that might not be criminal prosecution, but could be civil litigation. So again, this isn't a bill I'm going to support for the reasons that were stated by my colleagues over on the Democratic side, but I'd encourage the gentleman to perhaps revise the language on those two things. And I recognize you want to limit the discretion that Maine Justice has in dispensing its resources because you don't like what was done by the Biden administration with respect to whatever the previous initiative was. But this might go too far in the other extreme, even for what you're trying to accomplish. And with that, I yield back.
Gentleman yields back. Who seeks recognition? Question is on adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is adopted, a reporting quorum being present. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered to be reported favorably to the House.
Mr. Chairman?
The gentleman,
Roll call.
roll call being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Isa? Mr. Gates? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes aye. Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no.
Gentleman from North Dakota.
Mr. Armstrong votes yes. Ms. Escobar votes no.
Gentleman from California.
Mr. Correa, you are not recorded. Mr. Correa votes no.
Gentleman from Florida.
Mr. Gates votes aye.
I think we're short a little bit. How many do we need total? But I know we need to know the number. Can you count up the number?
Mr. Bishop votes aye.
Zella working on it? Ask him so.
Yeah, I'm texting too. I just need two. Yeah, you're good.
Gentleman from California?
Mr. Isa, you're not recorded. Mr. Isa votes aye.
Just need one more still. Daryl, thank you. Thank you. Sorry I missed your question today. I had to run to a quick little speech.
That's all right, I just ran out on Secretary Blinken, but I got the questions first.
Yeah. It's all Israel. What are you talking about?
Half Israel, Iran sanctions. He's wrong.
Yeah. Good.
Blinken, when Biden came into office, he was shipping 300,000 barrels a day. They're now shipping 2 million barrels a day out of Iran, and they want to talk about how great their sanctions are. They're not working. So too nice.
We need a member.
This is harder to do from this chair.
Ben Klein. We still need two? I thought I needed one.
It doesn't put us over. That's
Yeah, and the 23 puts us over.
23, not 22.
Oh. We need two more now. Hey, Caroline, how are you? We need 2 members. I'm gonna get my shoulder back in shape, Caroline. Whole train? No.
CSAM briefing, got a CSAM briefing from Google.
Okay.
Judiciary, so, when the vote comes, it's needed
Okay.
to vote, advocate
We
for
just
the next
need, we
bill.
need 2 more members right now is what we need, and we can get on with the next bill. Gentleman from Texas. Clerk,
Mr. Nels votes yes. Mr. Kiley, you're not recorded. Mr. Kiley votes aye.
clerk will report.
Mr. Chairman, there are 15 ayes and 8 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 7909, the Violence Against Women by Illegal Aliens Act, for purposes of markup, and move the committee report it favorably to the House. The clerk will report the bill.
H.R. 7909.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. McClintock, for an opening statement.
Thank you, Mr. Chairman. It's taken less than 3.5 years for President Biden and Secretary Mayorkas to release 5 million illegal aliens into the United States. Now, when you combine that with nearly 2 million gotaways who've evaded apprehension entirely and who've escaped into the United States, the illegal alien population has grown by nearly 7 million. 7 million since Joe Biden was inaugurated in January of 2021. At the same time the borders collapsed, President Biden and Secretary Mayorkas have abandoned any semblance of interior immigration enforcement. In a September 2021 memo, Secretary Mayorkas made enforcement more difficult for ICE officers. In the Mayorkas memo, training materials obtained by the committee and published in a Judiciary Committee staff report just last month, DHS failed to answer seemingly clear-cut questions, such as whether an alien who served a 20-year drug-related prison sentence or an alien who discharged a firearm outside a police station should be priorities for apprehension and removal. Those are the training materials required for all of ICE's enforcement personnel nationwide. Instead of making clear that ICE officers should carry out their duties to remove criminal aliens from American streets, DHS instructs ICE officers to develop a, quote, full profile of a criminal alien before deciding whether to arrest someone who's in the country illegally. In the training examples, that includes determining whether an illegal alien has high blood pressure or is a caregiver. The Biden administration's immigration absurdity apparently knows no bounds. In an interview with the committee, a former top ICE official recently admitted that the Biden administration's policies have made immigration enforcement more dangerous for ICE officers, more difficult to carry out, and less efficient overall. The ICE official even acknowledged that because of the border crisis, fewer ICE officers are available to track down public safety and national security threats because they're left to do border-related paperwork. Here's how that's working out. In fiscal year 2019, the Trump administration arrested aliens who accounted for about 5,500 convictions and charges for family offenses. That number dropped from 5,500 to 3,500 in fiscal year 2023, a 36% decrease. In fiscal year 2019, ICE arrested aliens who were responsible for about 6,500 sex offenses and 5,000 sexual assault offenses. Under the Biden administration in fiscal 2023, ICE arrested aliens responsible for only 5,500 sex offenses and 4,500 sexual assault offenses, drops of 13% in each category. These aren't hypotheticals or simply just numbers. They're a reality for families across the country. Domestic violence remains prevalent in America, with nearly 5.3 million incidents among adult women in the United States each year. That violence results in nearly 1,300 deaths and 2 million injuries every year in the United States. Both the victims and perpetrators include illegal aliens, such as a 26-year-old Mexican national arrested by ICE in February of 2024 for a domestic violence conviction, and a 40-year-old Salvadorian national arrested for punching, choking, and threatening to kill a woman if she cooperated with authorities. This violence also extends to children. In February, an illegal alien was arrested in Alabama for allegedly raping a 14-year-old girl who, quote, could not consent to the intercourse as she was, quote, physically helpless or mentally incapacitated. In April, an illegal alien was arrested in Indiana for allegedly breaking into a Michigan mobile home park and sexually assaulting 2 young girls. And just earlier this month, authorities arrested a 20-year-old illegal alien for allegedly snatching an 11-year-old girl off the street in front of her Lake Worth, Florida home and sexually assaulting her. According to local officials, the Guatemalan national crossed the U.S.-Mexico border in early January, made his way to Florida shortly thereafter, and does not have an immigration court date until 2027. That's Joe Biden's immigration legacy. More unvetted aliens released into American communities, more criminal aliens on American streets, and more Americans endangered by radical, reckless policies. It seems the real war on women is perpetrated by the president's open border policies, which allow more sexual offenders, domestic violence offenders, and child abusers not only into the country, but also to remain in the country indefinitely, free from fear of deportation. American people can end this nightmare in a few months. If voters choose to fix this crisis in November, Republicans have proposed new laws that will allow the next president to secure the border and increase interior immigration enforcement beginning on day one. H.R. 7909 is just one of many of those bills. This measure, the Violence Against Women by Illegal Aliens Act, makes crystal clear that illegal aliens who commit sex offenses are inadmissible to and removable from the United States. The bill also fixes a discrepancy in current immigration law by creating a ground of inadmissibility for domestic violence to mirror the existing ground of removability for the same offenses. The bill also expands the current ground of inadmissibility for domestic violence by cross-referencing an existing statutory definition for sex offenses. Although many aliens can already be found inadmissible to and removable from the United States for certain sex offenses and domestic violence offenses, H.R. 7909 expands and clarifies the conduct for which an alien can be found removable from the country. The time is now to take seriously the danger of criminal aliens in the United States. Anything that makes it easier for adjudicators and officials to ensure a criminal alien's arrest and removal should receive overwhelming bipartisan support, particularly when it comes to sex offenses and domestic violence. I'd urge my colleagues to support the Violence Against Women by Illegal Aliens Act. It is simply common sense. I yield back the balance of my time.
Gentleman yields back. The ranking member is recognized.
Thank you, Mr. Chairman. Mr. Chairman, here we are again marking up a bill that is another attempt by the majority to scapegoat and fearmonger about immigrants. Despite its title, this bill will impact not only those who are undocumented, but also lawful permanent residents or green card holders. This bill will do nothing to secure our border or fix our broken immigration system. It does not close any gaps or fix any loopholes in the law. It is purely a messaging bill and an attempt to score cheap political points. H.R. 7909 purports to add new grounds of inadmissibility and deportability for, quote, sexual offenses, adds new grounds of inadmissibility for domestic violence and other related offenses, and expands the current ground for deportability for domestic violence. If that were where the bill stopped, it would be almost entirely redundant to current law. Let me repeat, because all of the conduct described here already constitutes a deportable offense, this bill would ensure that no additional dangerous individuals would face immigration consequences. Zero. But as has been the case in every one of the dozen or so immigration messaging bills we have considered so far, this sloppy, poorly conceived, poorly drafted legislation has far-reaching and unintended consequences. At least I hope they are unintended, because this bill includes overly broad definitions and lacks any waiver authority. It threatens to sweep in far more people than it should, including the survivors of domestic violence. Let's break down the problem. Sexual offenses and domestic violence are serious offenses, and if these bills fix some gap in current law, I would have no problem supporting this legislation. But that is not the case here. First, the sexual offenses in the inadmissibility and deportability sections of the bill are largely redundant. All serious sexual offenses are already covered under current law. Currently, an individual is rendered deportable if they are convicted of an aggravated felony, which includes rape, sexual abuse of a minor, or a crime of violence, which is defined as any, quote, offense that has as an element the use, attempted use, or threatened use of physical force against the person, close quote. In comparison, this bill would render deportable those convicted of, quote, sexual offenses, which is defined as, quote, a criminal offense that has an element involving a sexual act or sexual contact with another, close quote. These categories almost entirely overlap. Additionally, under the Immigration and Nationality Act, a non-citizen who is convicted of a crime involving moral turpitude, or a CIMT, is already subject to removal. Crimes in which there is intent to cause bodily harm have long been considered CIMTs. As such, people who are convicted of any crime where there is intent to cause bodily harm, like sexual assaults, are deportable. The inadmissibility grounds for CIMT are even broader, as one can be deemed inadmissible by either being convicted of or admitting to acts that constitute a CIMT. Again, if that were all this bill did, it would simply be a waste of our time. But even more significant concerns with this bill arise with the sections related to domestic violence. Under current law, people are deportable if they are convicted of domestic violence and other related crimes and can be deemed inadmissible if they commit the acts or are convicted of a CIMT, where the domestic violence or related offense has intent to cause bodily harm. So the crime of domestic violence is well covered by current law. However, this bill attempts to significantly expand the definition of domestic violence to include the Violence Against Women Act definition that is used for grants and funding. The current definition for domestic violence offenses under Title 18, which is what is currently used for deportability purposes, focuses on physical force. In contrast, the broader VAWA-based definition used in this bill would lead to more people being ineligible for status or subject to deportation and would sweep in a broader range of behaviors, including criminal charges where there might be any coercive actions, including economic coercion and coercive control. This will likely implicate survivors of domestic violence who have used violence in self-defense or who were accused by their abusers and were either unable to defend themselves or pled guilty to avoid having to go through the court process. The VAWA definition was never intended to be used as a criminal statute or to capture only criminal behavior. We know this because the statute specifically says it includes, quote, a pattern of any other coercive behavior committed, enabled, or solicited to gain or maintain power and control over a victim, including verbal, psychological, economic, or technological abuse that may or may not constitute criminal behavior, close quote. And you do not have to take my word for it. Nearly 180 national and local groups as part of the National Task Force to End Sexual and Domestic Violence echo these same concerns in their letter opposing this legislation. I ask unanimous consent to submit their letter for the record.
Without objection.
By layering immigration consequences onto the existing challenges of talking about domestic abuse, this legislation will almost certainly create a chilling effect in immigrant communities with regard to the reporting of crimes of domestic violence. Further, this bill attempts to create a new ground of inadmissibility for domestic violence, which does not require a conviction and does not have any of the exceptions that currently exist in the deportability grounds. Under current law, when an individual is convicted of domestic violence or stalking and therefore becomes deportable, there are exceptions if the government finds that the individual is not the primary perpetrator, was acting in self-defense, or the crime did not result in serious bodily injury. While domestic violence advocates have concerns about the effectiveness of these waivers, such waivers are not even an option in the new inadmissibility grounds under this bill, which means it would certainly lead to survivors being deemed inadmissible given the expansive definition and no conviction requirement. That is why so many domestic violence organizations oppose this legislation. We anticipate even more will voice their opposition if this bill ever makes it to the House floor. This bill is dangerous. I wish my Republican colleagues would work with us to fix our immigration system instead of moving these pointless messaging bills and attempting to score cheap political points. I urge my colleagues to oppose this legislation, and I yield back.
Gentleman yields back without objection. Other opening statements will be included in the record. The chair recognizes the gentleman from California for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to
Without
the
objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from California to explain the amendment.
Thank you, Mr. Chairman. This amendment more clearly cross-references the specific crimes delineated in the ground of removability for domestic violence that are not currently explicitly listed as grounds of admissibility. These crimes include stalking, child abuse, child neglect, child abandonment, and protection order violation. By adding these crimes to the grounds for inadmissibility, the Violence Against Women by Illegal Aliens Act ensures that dangerous criminal aliens can be removed from the United States. That's more than a messaging bill. That's a matter of protecting the people of our country. I yield back.
Gentleman yields back. Who seeks recognition? Question is,
Mr. Chairman,
gentleman, the ranking
An
member is
amendment at the
recognized. The clerk will report the amendment.
amendment to the amendment in the nature of a substitute to H.R. 7909 offered by Mr. Nadler. Page 2, line 2, insert.
Without objection, the amendment will be considered as read. The gentleman from New York is recognized to explain his amendment.
Mr. Chairman, as I discussed in my opening statement, this bill is an ill-conceived attempt to look tough on immigration while actively harming the very community this legislation purports to protect. Survivors of domestic violence are often counter-accused by their abusers and will often plead guilty to avoid court or jail time. Nearly 180 national and local groups that advocate for survivors of sexual and domestic violence have come out against this bill because it fails to protect the people who fall into that scenario. Without making these important distinctions between victims and perpetrators, this bill strips important protections from survivors of domestic violence that exist in current law, opening them up to the risk of deportation. But I should not be too surprised. Scapegoating immigrants and attempting to weaponize the crime of domestic violence is a time-honored tradition by Republicans. For example, the Trump administration reversed protections for asylum seekers who are fleeing unspeakable domestic violence in their home countries. And back in 2013, when the Senate passed its bipartisan comprehensive immigration reform legislation with 68 votes, one of the provisions forced in by Senate Republicans included a section making the crime of domestic violence a new inadmissibility ground. However, that legislation had important provisions to protect survivors of domestic violence, provisions that do not exist in this legislation. My amendment would add many of those important provisions, which are essential to protecting survivors and negating some of the unintended consequences of this misguided bill. First, my amendment makes the bill's impact prospective only. It is a general rule that laws are not retroactive unless legislation states otherwise. But as always, immigration is different. Numerous courts have recently applied immigration enforcement-focused laws retroactively, and unless we make a definitive statement here, this legislation could be applicable to past conduct as well. What does this mean in practice? Let's say 20 years ago, a domestic violence survivor used violence to defend herself from her abuser and pleaded guilty to that use of force. Under this bill, even though the offense she pleaded to did not have immigration consequences at the time, she now could become inadmissible or deportable. My amendment would fix this problem. It is my hope that my colleagues can support this simple clarifying change. Next, my amendment would strike the bill's new definition of domestic violence. As I noted in my opening statement, this definition was never meant to be used to capture criminal conduct. In fact, it explicitly says in the definition itself that it captures conduct that, quote, may or may not be criminal, unquote. There is a reason that domestic violence advocacy organizations are coming out in opposition to this legislation. They see this expanded definition as negatively impacting survivors and creating a chilling effect for reporting future crimes. This amendment also adds some important waivers. First, for crimes involving moral turpitude, there is a waiver available in current law if the individual can meet very strict criteria. Given that sexual crimes, domestic violence, and stalking are all crimes involving moral turpitude, having the same waiver as an option for these newly specified grounds simply makes sense. It will ensure we have the flexibility to stop survivors from being swept in. And then finally, under current law, a conviction for domestic violence or stalking has specific and important options for waivers for survivors, allowing the government to waive a conviction if certain criteria are met, including showing that the individual was not the primary perpetrator and that the crime was committed in self-defense. Unfortunately, the majority is attempting to add a new inadmissibility ground, but they do not even require a conviction or include any waivers. As it is, domestic violence survivors say these waivers are not as strong as they could be, but not to include them at all shows a shocking lack of empathy for survivors of domestic violence. This amendment follows the lead of the advocates for survivors of domestic violence to fix some of the many, many problems with this bill. I urge my colleagues to accept the amendment, and I yield back.
Gentleman yields back. The gentleman from California is recognized.
Mr. Chairman, I respectfully disagree completely with the ranking member. Let's start with the fact that under existing grounds of inadmissibility, an alien may already be found inadmissible for domestic violence offenses if those crimes qualify as a crime involving moral turpitude or aggravated felony. And guess what? For those crimes and grounds of inadmissibility, there are no explicit exceptions like the one proposed by this amendment. So while there's a similar exception for the domestic violence grounds of removability, keep in mind who those grounds apply to. Aliens here legally. Grounds of inadmissibility apply to aliens in the country illegally. No such exceptions necessary. It would expand the exceptions for illegal aliens. The claims that this is somehow unnecessary are ludicrous, considering our recent experience with this massive influx of very poorly vetted illegals released into our country by the administration. Take, for example, the fact that under current immigration law, there's no explicit ground of inadmissibility for illegal aliens who commit domestic violence offenses, despite a ground for removability for aliens who commit such offenses. I mean, I can go through the long list of exceptions that we have debated over and over again in this committee with respect to a variety of bills that Republicans have put forward and passed to protect the American people from this scourge. But I think I'll simply refer to those by reference and yield back the balance of my time.
Gentleman yields back. Gentleman from Georgia is recognized.
Gosh, you called on me, Mr. Chairman, before I had a chance to look up how many times it took Kevin McCarthy to win the speakership back in January. I think it was 15, 16, 17 times, 15 times over about a week. And then he was only able to serve for about 9 months before he was taken down and the House thrown into 3 weeks of turmoil and morass, unable to accomplish anything before a new speaker was elected. And since that speaker was elected, we've continued the same dysfunction throughout this entire 118th session, where nothing that this House has done has been to benefit the American people. So today, take today for instance, we just finished arguing about a China bashing bill, a China bashing bill. It passed out of the committee, and now the committee is taking up something that is totally unnecessary, with respect to aliens who commit sexual offenses. They are already deportable or excludable from entry. And so we're arguing about something that is already in the law that needs no further amplification. We just need to enforce the law. But because a guy who lives down in Florida and spends a lot of time up in New York these days on trial, because he said, I don't want you to do any legislation that has an impact on the challenges that we face at our border, we are not doing anything to benefit America in that regard. We're simply replowing ground that's already been plowed, planted, and is yielding fruit or benefit. We want to go back and plant some more seed. It's totally unnecessary, especially when we do have a situation at the border challenges that need to be addressed, but this Congress won't do it. This House won't do it. This House won't look into a question that many Americans have asked, which is why are, even though prices are coming down, but why are they so high? This Congress, this House, refuses to look at the problem of corporate profits driving inflation and what we can do to protect the American people from the ravages of corporate profiteering that is taking money from their pocketbooks, their well-earned money, and giving them less product as a result. Less product this year than they got last year, and more money for less product. It's a crime, and this committee refuses to look at things like that can actually help the American people. And so the American people see through these exercises, what we're doing today. I appreciate all of my colleagues here on this side of the aisle for being here to protect the American people from harm that some of this legislation would produce for them. But I really want us all to be working on legislation that actually helps the American people instead of being a do-nothing Congress parading around with China bashing and Mexico bashing, failing to do what needs to be done at the southern border, simply to tee up issues that their savior can run on in November. It's wrong. It's hurting the American people. American people are tired of it, and quite frankly, so am I. And with that, I'll yield back.
Gentleman yields back. Is there further discussion on the amendment? Mr. Van Drew.
Just, I'll try to be quick, and I really do think the world of my friend from Georgia. He's a good man, and he's a good politician as well. Once again, trying to take our eye off the ball, the Americans' people eye off what we're really looking at here. First of all, nobody told anybody not to do an immigration bill. The immigration bill, I've said it once, I've said it twice, I'll say it 3 times, I'll say it 10 times, I'll say it 1,000 times, that the Senate produced was a bad bill. Did nothing really substantive for catch and release, did not have remain in Mexico policy, didn't finish building the wall, had nothing like Title 42 in it, didn't do any of the things that we need to have done in order to button up and keep our borders safely. Why would we vote for that bill? The only reason somebody would support that bill, in my mind, is because you would want to pretend that you did something, but in reality did nothing at all. And the only thing worse than doing nothing is to pretend that you did something. We did do something. H.R. 2, it wasn't draconian, it wasn't mean-spirited, it wasn't wrong, it wasn't bad. It just buttoned up our border. And to repeat again for probably the 100th time, no country prevails without secure borders. And we're forgetting something else here, and it's really done well on the other side. They keep blurring the issue. They keep talking about just aliens or just immigrants. Nobody's speaking about legal immigrants. We are speaking about illegal immigrants. And it is a real problem. And I'm not going to list the crimes that they've committed. I'm not going to list the amount of money that it's cost us in taxes. It's cost our entire American community around the country. Not going to speak of what it has done in so many ways to the fabric of the country and what it's going to cost us into future years. We are going to continue to do bills like this, and I laud the author of the bill because we have to say it over and over and over again, because women are being attacked by illegals. Now, they're being attacked by legal people too, but the point is, we've asked for more trouble when we ask for people to be here, open our borders. We don't know who they are, where they're going, what they're doing. We know that some, including President Biden's own FBI director, said the country is more dangerous than it has ever been because of these issues. People on the terror watch list are getting into the country, and some of them are gotaways. So we're not going to give up. And, we digress to Mexico and China. Mexico does need to have the stay in Mexico policy and not use their country as a conduit for illegals to come into the United States of America. It's wrong and it's bad, and the United States of America should not tolerate it, nor do we have to tolerate it. And China, it's not China bashing. It's the reality of what China is doing as an aggressor in our world. And I don't want to talk about all these other issues. I just want to talk about one thing: the Violence Against Women by Illegal Aliens Act. Who can be against that? They shouldn't be here. We shouldn't even have to wait till something like that happens, but unfortunately we do. So at least, for God's sake, the very minimum, when this does happen, this person should be detained, go through due process, and then deported. It's that simple. It's no more complicated than that. With that, I yield back.
Gentleman yields back. So further discussion on the amendment, Mr. Ivey.
Thank you, Mr. Chairman. At one quick point about my friend from New Jersey's comments, and then I'll get to the actual legislation. But, the comment about the Senate bill, the bipartisan Senate bill being a bad bill, love it or hate it. I didn't love it necessarily either, but you can bring it up and amend it. All of the things you keep saying it's missing, you can add those as amendments. And I think we've demonstrated pretty clearly and repeatedly in this committee that pretty much any amendment the Republicans want, they can put on a bill. But
Will you yield for like 5 seconds?
I got a lot of ground to cover. If I got some at the end,
5 seconds.
I'll yield to you.
Those amendments that would make it, become H.R. 2, H.R. 2.
The gentleman has not
my
yielded,
time.
Mr.
Let me reclaim my
Andrew,
time.
Mr. Ivey.
With respect to the underlying amendment, here's the scenario that I dealt with as a prosecutor. Man beats woman. There's an intimate relationship. Let's say they're married or boyfriend, girlfriend. Woman calls police, 911. Police come and arrest the man. He gets charged with whatever the level of offense, simple assault, domestic violence charges. It would vary from jurisdiction to jurisdiction. He gets released on usually there's a protective order that's included, but he's released usually on personal recognizance. He contacts an attorney. Attorney says, file cross charges against the woman who charged you. So he goes to the court. You can do this in Maryland without even involving law enforcement. You just go to a commissioner, file the charges, and as long as the charges have all the elements of the offense, the commissioner is required to forward it through so that it gets on the criminal prosecution track. And depending on what the charge is, that can lead to the issuance of an arrest warrant against her. But the bottom line perspective, though, for folks we're talking about in this and the people who are raised in this letter that the chairman referenced from the National Task Force to End Sexual and Domestic Violence, the big complication becomes immigration status. So sometimes this defendant will hire a defense counsel who will then approach the woman and say, you know what, if these cases go forward, you could end up getting deported and being separated from your children. And the scenario that the ranking member raised, even if it's an act in self-defense, depending on how it's interpreted, it could be charged in common law district, common law is different in different states, but it could be charged as a mutual affray. And so the woman is then faced with the risk of moving forward and risking perhaps criminal prosecution, perhaps a conviction, deportation. Some of these women would be deported, quote unquote, to countries they, hadn't been to in decades or, maybe hadn't been to since they were little kids or whatever. Those are now states that are in disarray, jurisdictions or countries that are in disarray, like say Haiti, for example. And so the point that the task force is raising here is, by expanding these definitions that the ranking member's amendment is aimed at correcting or limiting, you're actually putting women at greater risk who are in this scenario because they have more things over their head that prevent them or militate against them coming forward and reaching out to the police. And so when I had to deal with this, we had to spend a great deal of time making sure that women in those communities understood that we weren't trying to activate any kind of deportation mechanism. And that was really important for more serious offenses too, like say murder, where you had this, not applicable to this regulation or this amendment here, but the conventional wisdom gets out in the community, even if you see something violent happen, you don't want to step forward because it creates this risk that you'll get deported too. So I understand the underlying goal here of the gentleman's amendment, but I would encourage you to rethink it. I'm going to vote against it for the reasons I've stated. It actually creates an environment that undermines the ability to prosecute these cases and makes it less likely that women who are in this scenario are going to come forward, especially when you have
The gentleman yield.
the protective order language. Yes, I will.
I assume you meant you were going to vote against the bill before the amendment.
I'm sorry. I will vote against the bill, but at least adopt the amendment to help to correct that issue. And I apologize to the chair for running over, and I yield back.
Gentleman's time has expired. Is there further discussion on the amendment? Seeing none, the question is on the amendment offered by the ranking member from New York. Those in favor say aye.
Aye.
Those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to. Recorded votes requested. The clerk will call the roll.
Mr. Jordan, Mr. Issa, Mr. Gates, Mr. Biggs, Mr. McClintock.
No.
Mr. McClintock votes no. Mr. Tiffany. Mr. Tiffany votes no. Mr. Massey. Mr. Massey votes no. Mr. Roy. Mr. Bishop. Mr. Bishop votes no. Ms. Sparts. Mr. Fitzgerald. Mr. Bentz. Mr. Bentz votes no. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Nels votes no. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Mr. Moran. Ms. Lee. Mr. Hunt. Mr. Fry. Mr. Fry votes no. Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson. Mr. Johnson votes aye. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Escobar, Ms. Ross, Ms. Bush, Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant votes aye. Ms. Hageman, you are not recorded. Ms. Hageman votes no. Mr. Gooden votes no.
How is Mr. Jordan recorded?
Mr. Jordan votes no.
The clerk will report.
Mr. Chairman, there are 5 ayes and 15 noes.
The amendment is not agreed to. Is there any further discussion on the amendment in the nature of a substitute? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no.
No. You want a recorded vote? You want a recorded vote?
The chairman calls for a recorded vote. The secretary call the roll.
Mr. Jordan? Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Gates? Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Nels votes yes. Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Fry votes aye. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Gates votes aye. Mr. Benz votes aye.
Clerk will report. Well, first, have all members voted? Clerk will report.
Mr. Chairman, there are 19 ayes and 6 noes.
19 ayes and 6 noes. The ayes have it. The bill is ordered to be reported favorably to the House, and members will have 2 days to submit views. Without objection, the bill would be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. That concludes the committee's business for today. If there's no further business, the committee stands adjourned.